We love busting a few myths around here. And for those of you who have been arrested, and first thing you're gonna do, I hope, is try to find somebody to protect your future. And you're gonna call a bunch of attorneys. And some of us are going to tell you, hey, I play golf with that judge. I'm friends with that prosecutor. Blah, 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 blah. Look, folks, I am here to bust the idea that you are going to get some special favors because the person you hired somehow knows this judge. I've been practicing criminal defense here in Central Florida for over 30 years. I know these people, all right? I know some of these prosecutors too, though it's such a revolving door. I mean, by the time I edit this video, half of them are gone. But that's okay. My point to you is this is a red flag. If an attorney is trying to sell you on their relationship and some special favor that you're going to get because they know this judge and they're connected, that is nonsense. That is not true. That is not happening. Cut the conversation short and go call somebody else, because that's not happening. Now, let's talk about what is happening. Because it is true. I know I'm talking out both sides of my mouth, but I'm not. You 100% need an attorney that knows the judge. What I mean by knowing the judge is we gather data after 30 plus years of defending cases in front of these judges. I know what these judges prefer. I know how these judges rule. I know how they don't rule. I know how they sentence. You need to know these things too. I need to be able to share that with you. We had a misdemeanor judge in Lake County that no matter what, on a driving while license suspended, everybody got a minimum of 30 days jail. If you hired an attorney that did not understand that concept and did not know this judge, you were screwed, because you need to find a way around that jail sentence. And if your attorney goes in there blind, there is no getting around that 30 days. So you've got to know that judge. I know plenty of judges that they prefer legal argument and case law maybe to testimony. They want brief testimony and lots of legal argument. Good, I can supply that. I know others that are just the opposite. You want to bring as many witnesses as you can, and they're not too keen on the case law and the legal argument. I get that too. I have some judges that I can't get them to decide a motion in limine, and I know this in advance. A motion in limine is a written document. All motions are typically written documents that we submit, and we ask for something. A motion is asking for something, and a motion in limine is asking to keep something out. I want to limit what this cop is going to say about people being drunk and driving. I want to limit what this cop is going to say that, well, gee, all drug dealers package their money like this. So what? I might package my money like that. That doesn't mean I'm a drug dealer. I want to limit certain testimony. And I know some judges, they don't like motions in limine. They will tell me repeatedly, Mr. Guidry, I'm going to reserve ruling on this. Make your objection at trial and we'll decide at trial, which I think defeats the purpose of the motion, because it takes an hour to argue the law. And then here you are having to stop the trial and argue the law in the middle of the trial. But whatever, you got to know these things, folks, okay? I know some judges that have not granted a motion to suppress in the 31 years I've defended criminal cases. They just don't grant motions. You need to know that, and I need to know that. If you hired somebody from God knows where, and they assume that this judge is fair on certain issues, that assumption will get you and him or her in big trouble. You have to know what is going on. One of the best judges, retired now in Seminole County, he pulled me aside once on a motion to dismiss and said, I don't grant motions to dismiss, Mr. Guidry. However, I grant a lot of JOAs, meaning just pick a damn jury here and I'm going to throw this thing out. And that's pretty much exactly what he did. But you have to know these things in advance in order to prepare your client and in order to prepare the case. So knowledge of the judge and the prosecutor is extremely important. But the myth is that somehow the fact that I play tennis with him or her, or now I play a lot of pickleball, that does not mean that I am going to get a special favor in the court. And I would never tell you that, because I know that's not true. And anybody that does tell you that, you need to cut them a little short. Another thing that is also important, obviously, is your attorney's reputation is important. So the fact that the judge does know your attorney's reputation, that I have been well prepared and an excellent attorney before that court for decades, they know that. everybody's reputation does matter. That is very important to how your case goes. I totally get that. But again, we're not taking that little statement of how important my reputation is or how important a judge's reputation all the way to say, yeah, but we played some golf, therefore why don't you hire me and you'll get a good deal. That is nonsense. Don't buy it. That is a red flag. If something happens to you in Central Florida, of course, this is where I practice. I hope that you'll give my office a call. Seminole County, Orange County, Lake County, Volusia County, Osceola County, Brevard. I'm here for you, and I thank you for watching. I thank you for maybe clicking some things to help us out, like a heart or a thumb up or a subscribe or a follow. All these things help. Thank you.